Okay, get this. What if your whole future didn't depend on the facts of your case, but on your judge's birthday? Sounds crazy, right? Well, that is the bizarre situation right at the heart of Felipa versus Canada, a legal case that all boiled down to one really surprising question.
Now, the question itself seems pretty straightforward, doesn't it? But oh man, the answer turned out to be so complicated it shot all the way up to Canada's Federal Court of Appeal. It basically forced this major showdown over how we should read our laws in the first place.
So, this whole thing kicks off with a man named Luis Felipa. He's a foreign national and he's facing removal from Canada. He applies for a judicial review, standard stuff, and his case gets assigned to a deputy judge. But just before the hearing, his lawyer finds something, well, unusual about the judge. Turns out, he was over 75 years old. And believe me, that one little fact, it changed absolutely everything. So right away, Felipa's lawyer jumps up and argues that the judge legally wasn't even allowed to hear the case. And boom, that kicks off a massive legal battle, all because the law itself seemed to be completely contradicting itself. It was saying two different things at the exact same time.
All right, let's really break this down, because this is where it gets interesting. On one hand, you've got the Federal Courts Act, and it's crystal clear. It says a judge ceases to hold office when they turn 75. End of story. But then you look at another section of the very same act, and it says that any person who has held office can be asked to come back and act as a judge. So, wait a minute. Can you really be forced to retire on your 75th birthday, only to be called back the very next day to do the exact same job? That was the puzzle, the contradiction the court had to solve. So you have 3 appeal judges looking at this. 2 of them decided, you know what? The answer isn't in the exact words on the page. We have to look at the big picture. They went looking for something called the spirit of the law. Basically, what Parliament was trying to do, even if they didn't spell it out perfectly.
And this quote from their opinion pretty much sums up their entire way of thinking. They said that any other interpretation would violate the manifest legislative policy that judges shouldn't work past 75. I mean, their core belief was that there's this super clear, consistent policy across all of Canadian law: judges retire at 75, period. And allowing someone to keep working as a deputy judge, well, that would just completely undermine that entire long-standing principle. And you know what? They had history to back them up. They pointed to this pattern that goes back almost 100 years. You look back to 1927, and the court that came before the federal court got a mandatory retirement age. Then, in 1960, a constitutional amendment made it the rule for all Superior Court judges. To the majority, this wasn't just a bunch of coincidences. It was a loud and clear signal of what Parliament always intended. When you boil it all down, their argument was really simple. It just defies common sense. I mean, think about it. How can a person be officially too old to hold office as a judge, but then be totally fine to act as a judge? It's the same job. It requires the same brain power, the same skill, the same stamina. For the majority, this looked like a ridiculous, illogical loophole that Parliament could have never, ever intended to create. But not everyone was on board. One judge, Justice Stratus, saw it completely differently. He basically said, hold on a second, and built a totally different case. He wasn't interested in the spirit of the law. He was focused only on its plain, literal text, what we call the letter of the law. And Justice Stratus's argument was, in a way, refreshingly simple. He said, look, if Parliament wanted an age limit for deputy judges, they would have written one in. He pointed out that Parliament knows exactly how to impose mandatory retirement. They do it explicitly in all sorts of other laws. The fact that this specific section on deputy judges is silent on age, that's not an accident. That's not an oversight. That's a deliberate choice. And he really broke it down with some sharp textual clues. He argued that the law makes this really careful distinction between judges who hold office and deputies who just act as a judge. He said, hey, those aren't just the same things said differently. They are legally distinct statuses. And since the retirement rule only applies to those who hold office, well, it just doesn't apply to deputy judges. For Justice Stratus, the text was the text. It was perfectly clear, and it was the court's job to follow what was written, not to start guessing what Parliament might have been thinking. So, there you have it. That's the showdown. On one side, you've got an argument built on common sense, on history, on the overall policy of the law. And on the other side, you've got this precise, powerful argument based on the exact words written down in the statute. So, which one wins?
Okay, so after hearing both of these powerful arguments, the Federal Court of Appeal had to make a call.
And the vote came in, 2-1.
And in the end, it was the majority view that carried the day. Luis Felipa's appeal was allowed. The court officially ruled that a judge over the age of 75 could not act as a deputy judge of the federal court. The spirit of the law had won out over the letter.
What this decision really brings to light is this powerful legal idea called an implied limitation. Basically, the court decided that even though an age limit wasn't written down in black and white for deputy judges, that limit was implied by the entire legal system around it. Parliament's bigger policy against judges working past 75 was effectively read into the law, adding a rule that, well, wasn't literally there.
And all of this leaves us with a huge, fundamental question that goes way beyond this one case. When a law isn't totally clear, what should judges do? Should they stick rigidly to the words on the page, no matter what? Or should they try to figure out the law's bigger purpose, even if that means reading between the lines? The case of Felipa versus Canada is a perfect example that, in law, there's almost never an easy answer.